Hey guys, welcome back. Today's video brings you 3 absolutely jaw-dropping sovereign citizen cases that quickly spiral from strange legal theories into full-blown chaos. We start with a deeply disturbing family situation involving a young sovereign citizen whose own mother says she no longer feels safe around him after a violent incident allegedly involving scissors and a later confrontation with his uncle that ended in stabbing as he was being removed from the home. Then we shift into a classic roadside meltdown, where another sovereign citizen gets pulled over and insists the entire traffic stop is illegal because he claims he's not driving, just traveling, and therefore not subject to any laws tied to commerce. And finally, we look at a man facing the very real possibility of losing his home after attempting to erase his property tax debt using so-called sovereign citizen discharge paperwork that authorities flat out rejected. Each case escalates in its own way, but the common thread is the same: legal fantasy colliding hard with real-world consequences. Let's jump straight into the first one.
All right, Miss Gray, what would you like to tell me? I'm most interested in whether you wish to have contact with the defendant and if you have concerns for your safety.
Yes, I do. I also have other kids in the home. I have a 23-year-old daughter in the home. I have a 15-year-old son in the home. I have an 8-year-old daughter in the home. Mr. Gray is my oldest child. He drops in and drops out. Okay. I can't have someone come there terrorizing me and my kids in the home that I have built for the last 16 years. My husband and I have built for the last 16 years. Mr. Gray is on some mess trying to live like he's one of those sovereignty people, those people that squatter all the time and just take over people things, because they don't want to get up and get it on their own.
All right, so it's fair to say you don't wish for him to return to that address.
I don't wish for him to return to the address. No.
Yes, ma'am.
I feel like it would be unsafe. It would be unsafe for me, my husband, and my other 3 kids.
All right. I do appreciate you coming to court making that statement. Defendant's going to receive $1,500 surety bond. He's to have no contact with Ms. Gray or Mr. Robinson during the pendency of this case. He's to stay away from that location, have no alcohol, no drugs, no weapons. His case is going to state all purpose on March the 10th, and I am going to ask that a social worker visit for additional development of the matter. Best of luck to you, Mr. Gray. That concludes your case for today and to all parties concerned.
And just like that, the first case wraps up, yet again showing how quickly sovereign citizen-style thinking can turn already tense family situations into complete chaos, leaving relationships in ruins over beliefs that don't match reality. If there were a handbook for becoming the person nobody wants at family gatherings, this would probably be chapter 1. But the situation only gets more unbelievable from here. In the next case, a sovereign citizen is pulled over for something as minor as a faulty tail light, but what should have been a simple routine stop instantly escalates into the familiar, "I'm not driving, I'm traveling" argument. As officers continue the stop, things get worse when it's revealed he doesn't even have insurance, leading to multiple citations that he confidently dismisses based on his personal interpretation of the law, an interpretation that, of course, holds no weight in the real world.
And so for you, Mr. Nope, is it still your intention to move forward with a contested hearing?
I'm sorry, sir. I'm having a very difficult time hearing you. Could you please speak a little louder?
Sure. I was just confirming it's still your intention to move forward with a contested hearing today.
Well, sir, I am being put in a contested hearing box, but if you've noticed all the documents I've set to the court, I'm challenging much more than that, including I'm here by special appearance only. I'm not here by general appearance. I'm challenging jurisdiction. I'm challenging every aspect of this, and violations of due process, violations of law, and the fact that I was never notified about this and that it was already turned into a committed without me ever receiving any notification. Have you had a chance to review all of my letters and requests for disclosure and discovery, my affidavits? I've put many documents into this, and I'm challenging all aspects. So I can't really even say it's just a contested hearing, other than that's the only box you gave me any possibility to sign on this thing. And by the way, this was only a warning I was given. I was never issued a citation. The citation is not a the warning is not a charging instrument. It's simply a warning. I've been stopped times before and no citations were issued, and I've been stopped after and no citations were issued. This one suddenly miraculously turned into a citation long after the fact, and it was already termed committed, which is absolutely a violation of my due process. I would also challenge entirely the officer's report and the citation and many other aspects in regard to due process and law. And I can say much more if you will allow me.
All right, well, Mr. Nope, give me a moment here. I do have all your documents here, and I'm looking at the docket notes for your case as well. So let me take a look at a couple of things here, sir. Okay,
I'm sorry, I couldn't hear that last part.
I said I've got your documents here in front of me, and I'm going to take a look at a few things here before we move forward. I'm going to get myself more up to speed, but I do have all your documents here, so give me a moment, please.
Okay, thank you.
All right, Mr. No, have you received any documentation from the prosecutor's office in response to your demand for discovery? Looks like that was filed on January 13th.
Well, no response was ever made to all my requests for disclosure and discovery or my affidavits. So I would assume they stand as fact in law. They were not rebutted or they were never answered. Then I did get from the office, not from the prosecutor himself, but from the office, from some woman claiming to write the affidavit, and sent a copy again of the officer's report, which I will contest every element of, and the citation again, as if that is all I'm entitled to in terms of discovery and disclosure, which I do not believe is proper. That is why I already put in my motion to dismiss for violations of due process. I have done this before. I have been conferring with legal professionals all the way through this, including a professor of law at a major law university. And everything I'm doing, it has a basis in law and is about my due process. I'm not in the category or status that it can be limited in the way that it seems to be trying to be limited. And I can read that off for you I have it written down if you would like, though it is in my affidavits and all my other requests. I'm not, I've been misidentified. That's in my affidavit. I'm not an incorporated person or 14th Amendment citizen. I have been mistreated by this court very badly in the past. And my proof of my foundational instrument, a handwritten cursive note of real birth, not a birth certificate issued on bank paper, none of that. I introduced that as evidence in this court once before, and they took it from me and never returned it. So that evidence being taken from me and never returned has caused great problems. But I've done the affidavit that shows I'm not in the debtor category. I'm not a 14th Amendment citizen. I'm not an incorporated citizen. All of those, as well as the misidentification in all capital letters, which has real foundations in law. So I've asked for this to be dismissed in many ways, and I'm still asking for that. And I will contest many elements in the officer's report, citation, and the circumstances in which it occurred, which were very improper.
Honestly, someone should probably issue a public safety warning before the next sovereign citizen starts launching into another wall of word salad filled with constitutional buzzwords and self-invented legal theories. In this case, the driver genuinely believes that declaring himself a 14th Amendment non-citizen somehow exempts him from basic traffic laws. But the reality is far less dramatic. Even in a state like Washington State, where people sometimes try these arguments in court or during traffic stops, the law is actually very straightforward. Under RCW 46.30.020, No person operating a motor vehicle on public roads is allowed to do so without valid insurance. There's no exception for political beliefs, personal interpretations, or internet-made legal scripts. So while the speech may sound confident and complicated, it ultimately doesn't change the outcome. No matter how he frames it, the law applies and the violation still stands.
All right, so what we're going to do, Mr. Nope, I'm going to put you under oath. All right, I'm going to ask you some questions about what happened, and I'll try to also kind of walk through, how we got here. So please raise your right hand. All right, you swear affirm the testimony you're about to provide is the truth, the whole truth?
As best I can remember, yes.
So first of all, to address the issue with the earlier finding of committed, it looks like that was found committed due to a failure to respond, which does happen after folks don't respond to a traffic ticket. Part of that notice of infraction that you get does outline ways to respond and some deadlines, and we don't hear a response that becomes a found committed. Now you're here, which means if folks, even after it's found committed, if they engage with the court and set a hearing, then they are able to come back and contest their tickets here. So we are here at a contested hearing despite that earlier finding of committed. All right, now it sounds to me like based on what you've submitted and what you're saying today, you've got two issues here. It's like the stop and then the issue with driving without insurance.
Yes,
right,
this is not a moving violation. This is a paperwork's warning.
Well, I'll let you. I've read the police officer's report as well. I know you've already said made some arguments here, but now you're under oath, so I'll go ahead and let you explain your position with respect to what's in the officer's report. That is what we're focusing on here, is just that October 11th traffic stop and the allegation of driving without insurance. So go ahead.
Okay, so I want to make sure I understand. You're telling me I'm only have the opportunity now to challenge the officer's report right now? Is that what you're asking for?
Well, no, I'm saying that's the officer's report is alleging you were driving without insurance. And if you want me to find that not committed, I would suggest that that's what you focus your arguments on.
Okay. If you look at the officer's report, it is false where he states he was in the very beginning. The officer was down a side street, perpendicular to the road coming down out of Rainier. Perpendicular, hiding in the dark on a side street at approximately 12 midnight. I saw the officer car from way ahead. It's a 25-mile-an-hour speed zone at the bottom of a hill, but I was not speeding, nor did he stop me for speeding. Hang on. The officer could not see my brake lights, one brake light that he's claiming was out from that position. Also, I might add, there were two officers, and that's omitted completely from this officer's report. There were two officers, and one tried to give me legal advice. Now, I was not speeding. I saw him. I went down the hill. He was already pulling out after me before he could ever see any brake lights. Then, as I went forward to the stop there, the stop sign in the town of Rainier, that would be the only place he could have seen that. He is misstating completely. First of all, he was not driving, as he said. He was parked down a side road.
I'm going to just butt in here a little bit. So you're not cited for driving without a brake light. I understand that was the reason for the stop. The citation here is for driving without having your insurance.
Right, I'm getting to that.
Right. I would suggest that you get to that a little bit quicker.
Well, these are the circumstances that prove that he's not telling the truth. In my point of view.
At this point, his entire argument is built on a distorted version of reality, shaped by internet legal experts and self-proclaimed gurus who seem to have handed him some of the worst legal advice imaginable. Sovereign citizen rhetoric often revolves around the belief that they've discovered hidden loopholes that place them above the law, while everyone else, judges, attorneys, law enforcement, and actual legal professionals, somehow just doesn't understand the truth. The level of confidence behind it is almost unreal. But the problem is simple. No amount of wordplay, pseudo-legal terminology, or courtroom theatrics changes how the law actually works. The moment these theories collide with real statutes and real-world enforcement, they fall apart instantly, leaving nothing behind except confusion, frustration, and consequences that apply just like they do for everyone else.
So, he's not even saying properly where it occurred, because I was stopped out on the highway. He then followed me after I made the turn on Highway 507 toward Yelm, and followed me for a great distance before he made the stop. So his report is false, where he's even saying he stopped me. It was not at the intersection of Binghamton and Idaho streets. That was where he was hiding, down low, where it started from. That's not where he stopped me at all. So that is false. The next thing is he is not telling the truth about the discussion that went down there. And I put him on notice if any of my rights were violated or my due process was violated, that I would take the matter further into court. And that is what I'm doing. So many elements of this are improper. So I asked for this officer's report to be a cause for dismissal, as well as all the other things I've motioned.
Well, Mr. Nope, what you haven't said is you haven't denied that you were driving without insurance. Is that what you're arguing?
Well, the point is are you making me an offer as if I have insurance now, or are you asking me a question about then?
On October 11th, 2025.
I think I have the right to not answer that question under the Fifth Amendment because of all the other issues I've outlined that are improper in this case.
Well, Mr. Nope, you don't have to answer, but the officer said that when he pulled you over, indicated that you didn't have insurance, and driving without insurance is an infraction under state law. And so I do find that infraction has been committed.
Wait a minute. That is not what he said. He said I didn't show him proof in that moment. He then demanded that I email the proof to him, which is not proper or due process at all. It was not that I did not have it or show it. He simply claimed that I did not show him proof at that moment.
Are you saying you showed him proof?
What's that?
Are you telling me that you showed him proof of your insurance?
I handed him a bunch of stuff that I wanted to get out of there because I felt the situation was very dangerous. I don't recall what I actually handed him, but I also gave him the discussion that I'm not operating in commerce and I do not believe I am required to carry commercial insurance as that RCW is suggesting, or that it can be proven to apply to me.
It's actually pretty rare to hear a sovereign citizen openly state, without hesitation, that laws don't apply to them. Most tend to wrap their claims in layers of pseudo-legal jargon, misinterpreted constitutional references, or the familiar, I'm traveling, not driving argument. But in this case, the defendant essentially skips the usual script and goes straight to the core belief that he's outside the legal system altogether. Once a courtroom argument reaches that point, there's really not much left to interpret or debate. The legal theories fall apart under basic scrutiny, the explanations stop making sense, and the process shifts back to what it always comes down to: applying the law as it actually exists and letting the court bring the situation back to reality through its ruling.
All right, well, Mr. Nope, I am finding that the infraction committed, the RCW does say failure to provide proof of motor vehicle insurance is a traffic infraction, and you are required to carry motor vehicle insurance while driving on the public road. So I do find that committed. All right, you'll have 60 days to pay that the ticket amount. And I understand that's not the outcome you're looking for here today, but that's the ruling of the court.
Then, well, I would like to say something more.
Well, Mr. You do, there is an appeal process. All right, we got a lot of folks on the calendar today, and we are going to move on.
I need to ask about appeal. I need to appeal this then.
All right.
So
well,
I need to get the form for informa pauperis to be able to appeal this, because I cannot pay the fine or the filing fees to appeal this. So I will be appealing this, and I need to know what I have to do.
What you got to do is you contact the Thurston County Superior Court Clerk's Office, and they can get you all the information you need for appealing a traffic citation out of district court. That's where the appeal goes.
And how much time do I have to do that?
They'll be able to tell you that process is over in Superior Court. So talk to them and they'll let you.
And that brings hearing number 2 to a close. Yet another striking example of a sovereign citizen stepping into court armed with internet-born theories, only to run straight into the reality of how actual law works. It's almost difficult to imagine the level of confidence required to believe you've uncovered secret legal loopholes that somehow every judge, lawyer, and law enforcement officer has collectively missed, while none of it holds up under even basic legal scrutiny. But even as that chaos settles, the situation only escalates from here. Now we move into case number 3, where another sovereign citizen is about to find out the hard way that attempting to discharge legitimate debt with fake treasury-style paperwork does nothing to stop enforcement actions, especially when it comes to unpaid property taxes that the system continues to pursue regardless of the theory behind it.
Mr. Powell, would you unmute yourself, turn on your camera, and state your name, please?
Powell, Michael Elliott, authorized agent for Michael Elliott Powell.
Ms. Soroka, what property?
Yes, Your Honor, Amanda Soroka with Wayne County Corporation Counsel appearing on behalf of the treasurer, and Mr. Powell's objection to foreclosure of the residential property located at Portlands in Detroit with parcel ID number 21020155 is based on his statement that the taxes have been paid and exempt from levy. However, currently there's a property tax delinquency in the amount of $1,931.34, which consists of tax year 2023. And this is the date and time designated for Mr. Powell to be provided with an opportunity to address the court.
Mr. Powell.
Okay, let me open up the email because she didn't state the entire objection. I've been waiting for about 3 hours, so I didn't know you guys gave me improper notice. I had to call in and get the meeting ID, and I'm currently doing something. So I'm about to pull open this email that I sent them so we could get to the bottom of it. That wasn't the entire objection. The entire objection is, okay, taxes been paid, and what she said, property or security so deposited is exempt from levy. I tendered twice the amount in December. So in December, it was due $1,881.64. I tendered a total of $3,763.28 in security, exclusive of interest, costs, and attorney fees on the liens entered against me on the official tax of Eric R. Sabri. These payments equal to the amounts which I was liable for under the official tax. I presented a verified claim for $1,881.64 to the treasurer. The claim contained the statement of facts stated right now and demanded payment of the $1,881.64 in conformity with the official tax of the treasurer. More than 45 days has elapsed since that presentation and demand of claim, during which time Eric R. Sabri has failed to allow or reject the claim. So he's in default for not returning my security to the delinquent tax revolving fund. Everything has been provided to them, and
Your Honor, the fact remains that there is a property tax delinquency for 2023 in the amount of $1,931.34. If this amount is not paid in full, or a payment agreement has not been entered into by March 31st of 2026, the property will be foreclosed.
Okay.
We would recommend that you speak to one of the treasurer's representatives who is here today to enter into a payment agreement or to be provided with payment options.
That's not a response to what I said. So I already tendered payment. It's in your possession, and I have a receipt from Comerica Bank that you deposited my payment in Comerica Bank. So you keep saying that your record is incorrect, and I know that. I
Okay,
just said I filed a
excuse me,
claim.
sir. Excuse me,
Yes,
sir.
ma'am.
Did you attach a copy of the proof that you
No,
made the payment?
no, because nobody asked me to.
Well, if you're gonna,
The opposite party has not requested any type of proof. So affidavit, unchallenged affidavit is proof. She hasn't challenged any part of what I just said.
okay,
All she
Mr.
did was, I'm just, go ahead.
At this time, what if you're saying that you made the payment, all we need to do to confirm it so that we can get this off the tax roll is verification. Mr. Rhodes,
Right.
hold
And
on, hold on,
I would
hold on,
like her to go get what's in the
hold
Comerica
on.
Bank and show the court what they put in Comerica Bank, because at this point
No,
they
no, no,
lost
no,
it.
no, 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 no. No,
Okay.
if you made a deposit, that you
You want the
just have to
receipt?
have your proof. But anyway, Mr.
I
Rhodes,
sent proof. Go ahead.
excuse me.
I
You
said I
want
sent
just
proof.
speak, just hold on, sir.
Your Honor, any payments that would have been made by Mr. Powell would have been applied to any tax delinquency. Usually it is applied to prior tax delinquency years, and then what is remaining is this $1,931.34 for tax year 2023.
Is there,
Right. And I've spoken with somebody at the Treasury Department multiple times and provided proof. Okay. I sent a claim
Your
on
Honor,
the
if I
amount
may.
on the
hold on
amount
one
on
second.
I sent a claim on the amount I paid. It's been more than 45 days. It has not been rejected. I have not
Okay,
been
hold on.
contacted about, and that's accord and satisfaction.
Your
I
Honor,
sent
it seems to me that Mr. Powell is assuming that there is some sort of breach of contract here on the part of the treasurer. But the Wayne County treasurer, in performing his duties, is not classified as a debt collector in the state of Michigan, and is therefore statutorily exempt from the definition of the debt collector under the Fair
I
Debt
didn't say the
Collection
word debt
Hold on.
collector.
Okay, Mr. Powell, you cannot interrupt, please. Thank you. Go
And
ahead.
Hutch, this is not a contract or an accord or satisfaction or any sort of, situation that Mr. Powell is claiming. I think Attorney Don Lee Cotton has looked up the tax payments and would like to address the court.
Ms. Khan?
Yes, Your Honor. Mr. Powell has been in contact with our office, and we've spoken to him multiple times as to what he sent into Comerica Bank. And I just forwarded to Attorney Soroki what indeed was submitted was just the tax bill where he stamped it, just stating that it was 10.
Yeah, this is where the reality check really hits. That's simply not how debt works in the real world. You can't take an official-looking stamp, print a self-made document, declare a balance discharged, and expect banks, courts, or government agencies to treat it as payment. If sovereign citizen logic actually held up, everyone would be buying houses, cars, and high-value property with nothing more than homemade paperwork and internet-born financial loopholes. But real systems don't run on symbolism or templates copied from conspiracy forums. They require legitimate, verifiable payment in recognized legal form. Whether it's a lender, a court, or a tax authority, the standard is the same. Actual legal tender or officially accepted financial settlement, not pseudo-legal documents. And if this situation is going to change for him, it won't be through stamps or slogans. It will be through something far more concrete than anything in that envelope.
Okay, but
He didn't
if
send
you
a
didn't pay any
cashier's
money,
check. He
That's
didn't
not what
send a
happened.
money order.
That nobody asked me what happened. So let me go ahead and clarify. I have the right to send a bond to the treasurer secured by public obligations. I sent the bond to the treasurer secured by the public obligations of the court or of the county. I have the law to tell you on the record right
no,
now.
you don't
So
need
if
to
I
tell, you
met,
don't need to tell me the law.
okay, well
Hold
they
on,
said
Mr.
I'm
Powell, the only thing you need to do, you need to pay the
I
1,000.
did. I
Hold on,
did.
sir. Mr. Powell, I told you stop interrupting, please.
Okay,
Nobody
y'all
said,
interrupted me.
you know what, Mr. Powell, we're gonna put you on mute because you don't know how to let someone else speak. Everyone else is letting you speak. Anyway, if he has not paid the funds, not sending a document, putting whatever he wanted to on it. If the funds have not been paid in US currency or US currency equivalent, the debt has not been satisfied. So at this point in time, Mr. Powell, you owe 1,000, and correct me if I'm wrong, somebody, $1,931.34. Did I say that correctly?
Yes, Your Honor.
You owe that in tender
May I correct
US, no, you cannot.
You said correct you if you're wrong. You just said somebody correct me if I'm wrong. Now you said I can't.
I was talking to the
You
county.
said somebody. You didn't say county.
Anyway, as I indicated, if it has not been tendered in US currency, not putting a statement on it, that is not sufficient. You must pay the $1,931.34 by March 31st, or else there will be a foreclosure on this property.
I understand what you just said. Now you just said before that equivalent US currency.
No, I didn't. No. I'm done.
It's been recorded.
Okay, fine.
It's been
know
recorded.
it has
You literally
been.
said currency.
Okay, but
okay, you said currency equivalent, ma'am.
If you haven't paid,
I did.
I'm done, Mr.
I have proof.
I'm done.
Okay,
I'm done. And as I indicated, if it's not satisfactory funds, if the funds have not been paid, then your property will be foreclosed on March the 31st. You need to make sure you pay that $1,931.34 by March 31st.
I'm going to tell you again.
You need to pay it by March 31st, or the property will be foreclosed on. No notice, no anything. If it doesn't satisfy, you don't pay those in US currency funds, and equivalent means a credit card, a checking account. That's all that's acceptable. If you do not do that, your property will be foreclosed upon March 31st. At this
I understand everything you're saying.
Okay, that's all.
Now may I be? Okay, why am I here if I can't be fully heard?
Because you're not.
I have the First Amendment right to be fully heard.
You have 2 minutes, sir. 2 minutes.
Okay, thank you for allowing my First Amendment right to be fully heard.
2 minutes.
Can I reset it since you interrupted me? So, I deposited cash equivalent according to United States law, which is the governing law of all United States currency. Title 31, United States Code, Section 9303 is the code that you're quoting without quoting it. So it says, I may use a government obligation for security instead of a surety bond, which is the same as using cash, check, or money order. I sent a bond, a claim to the treasurer with or secured by the public obligations of the treasurer, which I have the legal right to do, negotiable by delivery, which was deposited into Comerica Bank. I did not send it to Comerica Bank. I sent it to the P.O. box of the treasurer. However, they sent me a receipt signed by Comerica. So if they sent me a receipt by Comerica, that means the treasurer received my documentation, my documentary evidence, and deposited himself in Comerica Bank. I didn't send anything to Comerica Bank directly. I'm telling you, I have a receipt from Comerica Bank, signed Comerica. However, I sent it to the P.O. box of the treasurer. So the treasurer obviously sent it himself to Comerica Bank. Now, I haven't been rejected. Comerica Bank hasn't called me, has not sent back anything to me, has not rejected anything I sent whatsoever. However, they have accepted for more than 45 days now. Now, the law says clearly, using a government obligation for security instead of a surety bond is the same as using cash, check, or security. That's what a cash equivalent is. That's what it says in the United States law. Title 31, U.S. Code, Section 9303, if anybody would like to look that up.
Okay,
also,
your time is up, sir.
Hey, okay, listen, I will file a request for your oath of office and your bond. The other law is Michigan compiled law. The Michigan compiled law 221.87 at sequence, which is the accounts and settlement thereof.
At this point, the sovereign citizen argument completely collapses under even basic legal scrutiny. First, he cites a statute, MCL 221.87, that doesn't even match the issue he's trying to argue, when the relevant provision is actually MCL 211.87. which simply outlines how state and county treasurers handle delinquent property tax accounts, including interest and collection procedures. In other words, it has nothing to do with erasing debt through self-created paperwork or discharge claims. Then he invokes 31 U.S.C. Section 9303 as if it provides some kind of hidden financial workaround, when in reality it only relates to specific federal bonding requirements where certain government obligations may be used in place of private surety bonds in limited, formal contracting contexts. It does not authorize individuals to eliminate property tax liens with unofficial documents or internet-based theories. None of these arguments hold up in court or with Treasury authorities, and the legal reality is straightforward. If the outstanding taxes aren't paid with valid funds, enforcement doesn't stop, and foreclosure becomes a very real, legally grounded outcome rather than just a warning.
If they actually looked into the law, they would see that I deposited, which was supposed to be put into the delinquent tax revolving fund. And I could quote, right? I could read exactly what the law says
Okay,
for
no,
the record,
no,
because
you don't have to, Mr. I've given you more time than I indicated. So at this
then
point
you
in time,
indicate I don't have the right to be fully heard.
no, you don't. I gave you 2
I'm
minutes,
speaking
sir.
relevant. You
I
gave
gave you
me
2
2
minutes,
minutes.
sir.
So this is a privilege hearing.
No, thank you
This is a
very much. Well, that concludes this hearing, Mr. Powell. And as
okay. Let the record reflect.
that concludes this hearing. Thank you very much, sir.
And with that, we've reached the end of today's video. 3 separate sovereign citizen encounters that all follow the same predictable pattern. Confident theories, internet-driven legal advice, and complete misunderstanding of how real-world law actually works. Whether it was a family situation pushed into chaos, a traffic stop derailed by claims that laws don't apply, or an attempted foreclosure fight built on invalid paperwork, every case ultimately ends the same way. Reality takes over. Sovereign citizen arguments may sound persuasive in online echo chambers, but in courtrooms, on the roadside, and in official government processes, they fall apart quickly when measured against actual statutes and legal procedure. So if you enjoyed today's breakdown of courtroom chaos, legal misconceptions, and sovereign citizen failures, make sure to like, subscribe, and stick around for the next one.